Good evening, everyone. I hope my audio is clear. So today we will take up the topic judiciary. I'll tell you the important features of judiciary, then go forward. Check if my audio is clear. Judiciary is one of the important organ in state. State has three important organs. Judiciary is one such organ. The duty of judiciary is dispute resolution. Online students, can you please tell me if my voice is clear? Am I audible to you? I am not getting any replies from you. Alright, thank you. So, dispute resolution body. We call judiciary as dispute resolution body. We have three important organs. One is legislative, the other one is executive, the third one is judiciary. Judiciary is very important organ. In India, the Indian judiciary is most powerful judiciary in the planet. You need to understand, Indian judiciary is most powerful judiciary in the planet. No other judiciary has the powers Indian judiciary is having. What are those powers? Let me check. Judicial review. The power which it having is judicial review. We have three organs, right? Legislative, executive, judiciary. So judiciary will check the actions of executive and legislature. There is balance of power. There are checks and balances. Balance of power, checks and balances. And there is independence of judiciary in India. In India, the judiciary, the kind of judiciary we have is integrated and independent. Integrated and independent. Independent of other two organs. Integrated means local courts, above that we have high courts, above that we have Supreme Court. This is called integrated judiciary, right? So integrated judiciary, independent judiciary, the most powerful judiciary in the world is because it can check the actions of the executive, right? Article 13, it can easily check the actions of the executive. It can also check the laws made by the legislature. Article 21, due process of law, right? Before we used to have procedure established by law, and as process of due process of law, and under Article 21 it also checks the fairness, reason and logic behind the laws. The third important method, it is checking the power of executive, it's fine. It is checking the power of legislature, it is fine. All over the world the judiciary does the same work, but in India the special power is that it also reviews the constitutional amendment. See the magic. Who will make the constitutional amendment? Parliament. Parliament will make the constitutional amendment. If any constitutional amendment is made by the Parliament, that also will be reviewed by this particular judiciary, that is done by this basic structure doctrine. That is basic structure doctrine. Keshwananda Bharati case. So this is how Indian judiciary is becoming most powerful judiciary in the world. It is having power to review the constitutional amendment and also can say that that constitutional amendment is not valid based on basic structure doctrine. That is the reason why we are saying Indian judiciary is most powerful organ in the world, right? Most powerful judiciary in the world. So again, try to understand, Article 13 is talking about judicial review, mostly executive actions can be checked. The Article 21 gives them power over the checking the actions of the legislature, laws made by the legislature. Article 13, both legislature and executive, but it only checks against fundamental rights. If any particular law is against Part-3 of Indian Constitution, fundamental rights, then it will say unconstitutional. It can check the power of the executive, it can check the power of legislature to make the laws which are against fundamental rights. That is under Article 13. But when you go to Article 21, arbitrary actions of the executive can be checked, arbitrary laws can be checked, but arbitrary legislature laws cannot be checked before based on the procedure established by law, but later we come up with due process of law. Under due process of law, arbitrary actions of the executive, arbitrary actions of the legislature, both can be done, right? Both can be checked by the judiciary. That is the reason why we are saying it is important organ, most powerful organ. Unlike that, in Keshwananda Bharati case, 1973, in Keshwananda Bharati case, it had declared basic structure doctrine. According to basic structure doctrine, we need to understand any constitutional amendment made by the parliament. Constitutional amendments are made by the parliament. Any constitutional amendment made by the parliament can be nullified by judiciary using this particular basic structure doctrine. That is the reason why this is one of the important features which is making Indian judiciary most powerful judiciary all over the planet, all over the world, all over the cosmos, universe, right? Next, coming back, see parliament. If you remember parliament, if you remember 1947 when we became independent, we didn't have parliament. What we had is constitutional assembly. Constitutional assembly. We had constitutional assembly, and this constitutional assembly started working as a parliament. See the magic? Constitutional assembly is invested with the work of creating the constitution, right? The same way here, the same constitutional assembly started working as a parliament until 1952. But later, now we have parliament after 1952. This parliament is also becoming constitutional assembly. When it is making amendment, whenever it is making amendment, it is constituent assembly. Is it not? Constituent assembly. Parliament is not given power to. Parliament should not be the institution normally which amends the constitution. But if it is given work to amend the constitution, then you can consider that it as a constitutional assembly, right? So it is like now the constituent assembly itself making the amendment, and judiciary which came out of constitution is questioning that particular constitutional assembly's amendment, that is the parliament's amendment, right? So now here there is little imbalance in the power. Here judiciary is little more powerful in India as of now. After 1973, judiciary is more powerful in India. That is the reason why you see any dispute of public service commission is going to judiciary. High courts and judiciaries are deciding the fate of the public service commissions or major cases, right? Every single day judiciary, you can see judicial activism, we call it as. Every single day it is delivering judgments, right, based on the changes of the society. Even the constitution should imbibe the changes, right? Parliament should be parliament is entrusted with the duty of changing that constitution according to the changes in the society, and judiciary will make sure that those changes are not changing the basic structure doctrine, right? Not changing the basic structure of the constitution. So remember that. I'll tell you the few features again. So what are the different features of judiciary? It is independent judiciary, first point. The second one, it is integrated judiciary. Now if I tell this point, then you can understand the articles clearly. Then this is called dispute resolution body. This is called dispute resolution body. And what kind of system we have? Adversarial form of justice. So you can refer to NCRTs or you can refer to CBSE textbooks. Opposite to that is inquisitorial form of justice. The kind of justice we have is adversarial form of justice. Natural justice is practiced, right? So we have tribunals here in India. Tribunals are quasi judicial bodies. These are normally maintained by the administrative authority, quasi judicial bodies, right? These are normally headed by the administrative authorities. Tribunals, different tribunals are there: NGT, National Green Tribunal, CAT, Central Administrative Tribunal, State Administrative Tribunal. Likewise, tribunals are there, right? So apart from that, we have ADR ecosystem also, alternate dispute resolution mechanism. This is where we have arbitration, reconciliation, negotiation, mediation. So apart from the regular formal justice systems, we have alternative dispute resolution system. When we don't want to go to courts, we can go and settle it alternatively. Alternative dispute resolution. Dispute resolution bodies are these. Dispute resolution bodies, hierarchy, Supreme Court, High Court. We have 25 high courts and local courts. So we have 25 high courts in different geographies and 1 Supreme Court and different local courts at the district level, civil courts and criminal courts specifically divided. So apart from that, we have here National Legal Services Authority, State Legal Services Authority, District Legal Service Authority. From 1987, 38A, Article 38A, we have free legal aid. Free legal aid. Those people who don't have access to justice, they can avail free legal aid under Article 38A. Under Article 38A, free legal aid was an article amendment brought by Indira Gandhi according to 42nd Amendment Act 1976 again. 42nd Amendment Act 1976. We have created a system here, National Legal Service Authority, State Legal Service Authority, District Legal Service Authority. If a person, he don't have money, don't have finance to reach the institutions to hire a lawyer, to pay for the advocate, he simply approach District Legal Service Authority for free legal aid. He can just pay 1 rupee and get justice, right? That is how the system is there. So this is the normal ecosystem of judiciary. Adversarial form of justice is what we have, natural justice is followed, basic structure doctrine is very important doctrine, basic structure doctrine. And you know, we have new Chief Justice. Who is new Chief Justice now? Please type in the chat box. Who is our new Chief Justice? Please type it. So that is the ecosystem we have, and wherever the points come, I will try to add them, right? So first article 1 to 4, right? Article 1 to 4. Understand, this is legislature, this is executive, 4 is judiciary. As I said, little powerful, right? Now, as of now, it is little powerful, right? So you can remember this way. To check on 1, 2, we have created 4. LEJ. Article 1 to 4 is talking about establishment of Supreme Court. Supreme Court, where we have? We have it in Delhi. We have the Supreme Court in Delhi. And the kind of system we have is independent judiciary. We have this particular system, independent judiciary. We don't have legislature or executive influence over judiciary. That is how we have created, right? Remember Article 1 to 4, establishment of Supreme Court. So the retirement age for Supreme Court judges is 65 years. Justice Dhananjaya Chandrachud. Thank you. All right. So here Article 1 to 4 2b. Remember this article, write down this article 1 to 4 2b. This is talking about removal of judge. Judge may be removed from his office in the manner provided in class 4. Class 4 is where we have the procedure. How do we remove him? Right? Judges can be removed from office except by order of the president passed in address in each house of the parliament. See, this is what my question is. Judges can be removed by the parliament. According to Article 124 2b, judges can be removed by the legislature, which means legislature checking over judiciary. This is what checks and balances I am saying here. If judiciary is becoming more arbitrary, there should be one organ, right? There should be one organ to check it. So if judiciary judges are becoming more arbitrary, then it is the legislature which is coming to the rescue and checking it. They can be removed by the judiciary, they can be removed by the legislature. What should be the ground to remove? Misbehavior and incapacity. If you remember the impeachment of president, I spoke in Article 61. When you talk about impeachment of President of India, you need to understand the ground for removal is that not following the constitution, right? Here the ground for removal is misbehavior and incapacity. This is another important point which will prove that legislature is having checks and balances over judiciary. That is what we can understand, right? The parliament can initiate a resolution and remove a judge from the capacity. So National Judicial Commission Appointment Commission is one which we have brought, but it is nullified by the Supreme Court. 124A is an amendment through which we brought NJAC. NJAC is a process through which the legislature wanted to become involved in judiciary, but judiciary said that it is not part of basic structure doctrine. According to basic structure doctrine, independence of judiciary should be there. Legislature should not be part of appointments of judges. So that is the reason why we have not used that. The system through which we appoint judges now is collegium, right? 1 + 4 judges we have. with the concurrence of Chief Justice and 4 senior most judges, the appointments of the Supreme Court and the appointments of this particular high courts will be done. Appointments and transfers of high court will be done. The system is called collegium system. Collegium system is where they are maintaining independence of judiciary, but it is having one problem, that judiciary, they themselves are deciding their appointments. Judiciary, they themselves are deciding their appointments. What if you can select yourself as IAS? What if you can select yourself as IPS? Right? What if your parents can select you as IAS, IPS? The same way, it is against natural justice, right? They will have bias, that my son, my daughter, there will be bias. The same way, judiciary selecting judges is little against the natural justice, but the principle they are protecting is independence of judiciary, which is part of basic structure doctrine propounded in 1973 Keshwananda Bharti case, right? National Judicial Council, Appointments Commission. That commission is not there. That is nullified by the Supreme Court. So here, next important article is Article 125. Article 125 is talking about salaries of the judges. So the salaries will be specified in the second schedule. Temporarily, there are specifications in second schedule, but those numbers are different. Those are the salaries which we used to give in 1950. But now the salaries are changed. We have made a separate act. Parliament came up with a law, and according to that law, they are paying salaries. But remember why I am stressing on this particular article. Article 125 is talking about salary. Who should give the salary? It is the Consolidated Fund. Consolidated Fund of India, which is there in Article 2661, Part 12 of Indian Constitution. That is where the salary should come. The expenditure from this particular account, we have two accounts. One is voted, the other one is charged. The other one is charged expenditure. One is voted expenditure, the second one is charged expenditure. The salary is given to the judges is charged expenditure, remember. Which means that in Parliament, they can discuss about the salaries of the judges, but they cannot vote it, they cannot reduce it. That is where the independence of judiciary is protected again. They cannot reduce the salaries, they cannot remove the they cannot say no to the salaries, they cannot negotiate the salaries, because of which we can say the salaries is fixed and the age limit is fixed up to 65 years. Right, retirement age is 65 years, age is fixed, and similarly salaries are fixed. Similarly, removal procedure is little difficult. We need to introduce in Parliament. All these features are bringing up independence of judiciary. They will try to work in an independent environment without bias from the ministers, prime ministers or legislators. Right, that is what the agenda is. The salaries will be charged. And remember, the Supreme Court judges' salary, Supreme Court judges' pension, both are charged on salaries, and pension both are charged on Consolidated Fund of India, whereas High Court judges salaries are charged on Consolidated Fund of India, whereas pensions are charged on Consolidated Fund of State. High Court judges salaries are charged on Consolidated Fund of State, whereas pensions are charged on Consolidated Fund of India. Remember, Consolidated Fund of India or Consolidated Fund of State, both are mentioned in Article 2661. Article 2661 is talking about Consolidated Fund of India, 2662 is talking about Public Account of India, 267 is talking about Contingency Fund of India. These are in the Part 12 of Indian Constitution. So I hope you understood the article, importance of Article 125. I am only trying to stress and trying to present three important parameters: balance of power, checks and balances, and independence. In judiciary, when we are talking about checks and balances, balance of power and independence of judiciary. Independence of judiciary is one of the important principles of Indian Constitution, right? And then Supreme Court should be court of record. The Supreme Court shall be court of record and shall have all the powers of such a court, including power to punish for the contempt itself. Whatever the happenings, whatever the things happening before Supreme Court, right? Supreme Court and High Court is also court of record in India. Article 129, we can say court of record. Whatever you are saying in front of this court, everything will be recorded, and this can be used as evidence also further, right? So you will be taking oath and you will be presenting yourself in the court, and it is working as a it will be working as court of record, and it also work as precedent. When Supreme Court is giving a judgment, and that is a precedent and binding on all the courts in India. If it is saying that all women should be compensated equally, for example, let us say if it is giving that judgment, that judgment is binding on all the courts of India, all the judiciary of India. That is the reason why we also call this as apex court, highest court of India. Apex court, highest court. We also call it as apex court, highest court, right? So this is one important part. Article 129 and Article 130 talks about seat of Supreme Court. Where we have seat of Supreme Court is Delhi, right? But if we want to open one more Supreme Court, for example, if you want to open in Hyderabad, Chennai or Kolkata or anywhere else, right, then the Chief Justice in concurrence with the President can take such decisions to start one more Supreme Court in any other place. So the seat we have is in now Delhi. Right. Next one. Original jurisdiction. When we talk about jurisdiction, original jurisdiction, appellate jurisdiction and advisory jurisdiction. These are the three important jurisdictions we need to remember. What is the original jurisdiction? What is the reason why we are establishing this court? What is the original jurisdiction? So, if there are any disputes between Government of India and one or more states, if there are disputes between Government of India and Government of India, state and states other side, it's a permutation and combination between Government of India and states, between two or more states. If there is dispute between two states, federal units, then this is the original jurisdiction, right? When you have to go to Supreme Court, those people who have dispute with central government, right? States having disputes with central government, state versus state disputes, those are the disputes which should go to the Supreme Court. Supreme Court is also called as a federal court, also called as apex court, where this is the original jurisdiction. This is where they talk about this. And apart from this, from Article 32 of Indian Constitution, we have constitutional remedies. Constitutional remedies. As part of constitutional remedies also, one person, if their fundamental rights are violated by either a citizen, either by the state, they can directly reach to the apex court, right? That is also part of this particular original jurisdiction, fundamental rights. On violation of fundamental rights, you have constitutional remedies, which are writs, prerogative writs we call them, prerogative writs. There are different writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. These are the different writs we have. Prohibition, quo warranto, certiorari, mandamus, all these are the different writs we have, right? So these are the writs which we give if there are any violations in fundamental rights. But remember, Supreme Court on fundamental rights is having for over writs, it is having narrow jurisdiction. What is narrow jurisdiction? I mean, Supreme Court can issue writs only for violation of fundamental rights. Remember this point. Supreme Court can issue writs only for violation of fundamental rights. If there are violation of any legal rights, it cannot issue writs, but high courts can issue. High courts in India are having wide jurisdiction over writs. Writs can be issued by the High Court for both legal rights and fundamental rights, but Supreme Court can issue only for fundamental rights. All these are part of, right, original jurisdiction. And apart from that, appellate jurisdiction, some criminal cases from lower court and civil cases from lower court will come to the higher court, right? So these are the articles: Article 132, Article 133, 134, Article 132, 133, 134, these are the articles which are proving that Supreme Court is the apex court. This is the final court. There is no court of appeal above Supreme Court. There is no court of appeal above Supreme Court. Although we have checks and balances over judiciary, but we don't have any court above Supreme Court. Supreme Court is the final court of appeal. That we need to understand from Article 132, 133 and 134. We are talking about civil cases, criminal cases, appellate jurisdiction of Supreme Court in appeals from High Court regarding civil matters, and similarly appellate jurisdiction of Supreme Court in appeals from High Courts in certain cases, criminal and civil cases. This is criminal cases. So we can say that these are final court of appeals. Then you should understand, is appeal inherent right of the person? Is appeal inherent right of the person? Can anyone can go for appeal, right? So we have lower court, we can have high court, we have Supreme Court. You need to remember, appeal is not inherent right. You don't have right to appeal over lower court decision to high court decision to Supreme Court. If lower court is giving one decision, you cannot go to high court. Over that, you cannot go to Supreme Court. There are decisions taken by lower court and those decisions are final. Appeal is not inherent right. If it is mentioned in law, if Parliament is making a law that over on this particular issue, for example, Nirbhaya case, on Nirbhaya case, you can go for appeal, appealable. If it is mentioned appealable in the law, then only you can go for appeal. Else, high court is the final court, or lower court, if it is mentioning lower court is the final court. Remember that. But there is one option which is called SLP, special leave petition. Special leave petition. Although appeal is not inherent right, for example, lower court gave me a decision, I will go to high court and file an SLP. Ask for leave of business by the high court. I will ask, SLP is a petition, special leave petition. I will give a petition and say, sir, in lower court I didn't get justice. Please review my case. Please review my case and try to revise the judgment. If the judge feels that there is a case in this particular petition, then he will accept it. It is in the discretion of the judge. Can you see this? It is in the discretion of the judge to accept that particular case. If he is accepting that case, then SLP is accepted, then appeal is accepted. Simple, understood? Appeal is not inherent right. If it is mentioned in the law appealable, it can be appealable. But if it is not mentioned, lower court itself is the final court, high court itself is the final court, right? So if SLP can be filed in both Supreme Court and high courts, that is what we are talking about. Especially petition, don't confuse it with PIL. What is PIL? PIL is public interest litigation. What is public interest litigation? So normally, who can go to courts? Parties in disputes can go to courts. For example, me and my brother are fighting. Who can go to court? Me or my brother? My neighbor cannot go to court. That is called locus standi. Locus standi. For example, me and my brother are fighting for a property. Right? Me and my brother. I am P1 and he is P2. Both are fighting for a property. Right? If both are fighting for a property, only either me or my brother can go to court. My neighbor cannot go. My relatives cannot go because they don't have locus standi. They don't have a case. Right? The same way, PIL is a place where there is no locus standi. You don't need to be party to that particular case. I can file a case for public interest. For example, if there is an industry which was opened in my particular area, which is creating situation, which is polluting the water, which is polluting the air in the residential area, then I can go to high court or I can go to Supreme Court and file public interest litigation. Public interest litigation. I don't need to be part of that case. I don't need to be part of that particular area also. In the name of the public interest, I can file a case. Right? Special leave petition is different from PIL. PIL is judicial activism. PIL is judicial activism. With PIL, judiciary is saying that environment should be protected, pollution should not be there, water pollution, air pollution, land pollution should not be there. It is declaring rivers as legal persons. It is giving different rights. It is giving different social security benefits to people. It is saying that it is saying to take care of education. It is saying to take care of health. It is saying to take care of pensions. All this it is doing in the name of the public interest. So we can understand it is activism, that is called judicial activism. When judiciary is becoming hyperactive and working for the welfare of the people, which is the duty of the parliament, which if it is not doing, then you need to understand we call it as judicial activism. But if judicial activism is becoming more and if it is not useful to people, that is called judicial overreach. Judicial overreach is where judiciary step out of its own domain and get into the domains of legislature and executive and do the duty of legislature and executive. Remember the word judicial activism and judicial overreach. There is a thin line of difference between judicial activism and judicial overreach. So apart from that, we have article 143, I love you article 143, power of the president to consult Supreme Court. Article 143, I love you article. This is the article that is where president, if he is having any questions on law, then he can consult Supreme Court, Chief Justice and judges. That is called advisory jurisdiction. We heard about original jurisdiction, we heard about appellate jurisdiction. Now this is advisory jurisdiction, where judiciary will tender advices to the president. Remember here one point: Supreme Court is the final interpreter of Constitution. Remember this word. Supreme Court is the final interpreter of the Constitution, right? Take about religion. Who is the final interpreter of Hinduism or Bhagavad Gita? Who is final interpreter of Quran? Who is final interpreter of Bible, Jandavesta, any other holy book? There are many interpreters, right? There are mullahs, priests, fathers, brothers who are interpreting this book in different ways, different perspectives, different dimensions. Unlike that, Indian Constitution cannot be interpreted by anyone else other than constitutional body, which is judiciary. Right? Judiciary is the final interpreter. Whatever the interpretation given by the lower courts or the institution, judiciary will reveal the right interpretation. That is the final interpretation. Remember, we have letters in the Constitution. What we have in the Constitution is letters, but the spirit will be revealed by the Supreme Court. Remember, the letters are visible, spirit is not visible. Spirit will be revealed by the Supreme Court. That is where the judiciary is coming into role, right? So remember this particular point: judiciary is the final interpreter of the Constitution. There is no person who is and above, because of which Constitution cannot be interpreted in different dimensions, different ways, right? So there is no dispute in interpretation. It is the final interpreter. If High Court is saying a different version, Supreme Court can come up with a different decision. And one of the important point of Indian judiciary is that it can review its own judgment. Right? For example, if Supreme Court gave a judgment in 1951, in 1973 it can give complete contrast judgment. In 1951 it is giving a particular judgment, in 1973 it can give a complete contrast judgment. It can say, it can go against the judgment which it had given before, right? It can review its own judgments. Understand the dynamicity. It can review its own judgments also, right? It can review everything. That is the reason why we need to have this as a final interpreter. While this particular constitution is being interpreted, the minimum numbers to sit here is 5 members. Constitutional bench, right? Whenever we are interpreting constitution, 5 judges of the Supreme Court should sit here, and 7, 9, 11, 13 likewise. The highest constitutional bench we have is 13-member bench. 13-member bench, 6, 7 judgment, 6:7, 7 majority. KBC, Keshwananda Bharati case is the judgment we have. How many judges we have? 31 plus 2, 33 are the, 33 plus 1. The total number of judges we have in Supreme Court now is 33 plus 1. 33 judges, 1 Supreme Court. When we started, which is not the quite similar form, when we started Supreme Court in 1772, right, in 1774 in Fort William in West Bengal, that Supreme Court had 1 plus 3, 1 Chief Justice and 3 judges. Now what we have is 33 judges plus 1 Chief Justice. But remember, the Supreme Court we started in 1774 is not similar to the Supreme Court which we have now, but it is quite similar to the Supreme Court which we started under 1935 Government of India Act, which is a federal court. Okay, so we had most of the provisions which we imbibed from the 1935 Government of India Act, right? So this is the article. Remember article 132. 132. An appeal shall lie to Supreme Court from any judgment, decree or final order of the High Court in the territory of India, whether the civil, criminal or other proceedings. If the High Court certifies under article 134A that the case should involve substantial question of law as to the interpretation of the Constitution. As to the interpretation of the Constitution. Article 132 class 1 is clearly establishing that Supreme Court is the final interpreter of the Constitution. Even the High Court interpreted the Constitution. If High Court believes or the party believes that there is substantial question of law or interpretation of the Constitution, they can reach to Supreme Court and ask for an interpretation. The interpretation given by the Supreme Court will be final in India. The words which are said by the Supreme Court over the Constitution is final, right? So there cannot be many interpreters unlike the religions we have, right? 132(1). Remember that article. So next important one, 136, which I already said, SLP, right? Special leave of appeal, special leave petition is mentioned in 136. Then article 127. 137 is talking about review of judgments or orders by the Supreme Court, right? Supreme Court shall have power to review any judgment or pronounced order by it. I said this point also. I am trying to map the articles which I just said. Article 137 is talking about review of its own judgment, not the judicial review which I spoke in article 13. Now we have article 32 we have now, article 226 we have, article 137 we have. So these are the articles where review is coming, but article 137 is talking about review of its own judgment, right? Supreme Court can review its own judgment. Article 141, Apex Court. Law declared by Supreme Court to binding all courts. The law declared by Supreme Court shall be binding on all courts within the territory of India, right? Whether it is dispute resolution bodies or tribunals which are quasi-judicial bodies, all the bodies should follow the decisions given by the Supreme Court. It is binding. The decisions made by the Supreme Court is binding in all the courts, on all the courts. That is article 141, that is Apex Court. It is the final court again established. Most of the articles, when we see these articles, it is being established that it is the highest court. It is the highest court and it is the Apex Court. And 143 I spoke about advisory jurisdiction of President. Then rules of the court. How to run the court? The rules of the court can be done by the Supreme Court itself. Chief Justice can himself or High Court Chief Justice themselves can make a law for running the courts. Like rules of business of Lok Sabha, like rules of business of Rajya Sabha, these are the places where questions are coming. In last preliminary examination, rules of business of Lok Sabha, one question came. Two questions came actually. The same way, rules of business of Lok Sabha, rules of business of Rajya Sabha, similarly rules of business of courts. Courts can be decided by themselves. Courts will administer themselves, independent of judiciary, right? Tada! That particular judiciary is done. Most of the important articles and most of the important perceptions of this judiciary is done, Supreme Court, right? We will try to read another important article, article 148, then we will go ahead and read next part tomorrow, right? One of the important institution in India is CAG, Comptroller Auditor General, Comptroller Auditor General of India, article 148, right? He is called watchdog. Right? In reality, we call him as SAI, Supreme Audit Institution. Supreme Audit Institution. This is the person who will audit the accounts we have. The Consolidated Fund of India, the Contingency Fund of India, the Public Account of India, and all the accounts of public sector units, all the accounts of the state government will be audited by the CAG, Comptroller Auditor General. Right? Normally, controller is the word which we use if he is a private person, comptroller is used if he is public person, but remember the name is not good because he is not the controller, he is just the Auditor General of India. He is just the Auditor General of India. He is not controlling the funds, unlike the Britishers' time where they used to control the funds also. Now the control of funds is in the hands of Finance Ministry and Parliament, right? Parliament is the institution which will decide on the control, which will have control over the funds, right? And more or less it is the executive, but they don't have, the name is not justified here. He is just the Auditor General of India, but the name is still continuing, Comptroller Auditor General of India. When there is accounting, those accounts will be audited by this particular person, right? One of the important feature here is to remove this particular person. He should be removed as if he is a Supreme Court Chief Justice or Supreme Court Judge. The process to remove Comptroller Auditor General is the same process to remove judges. So you need to understand, to remove him, it is very difficult. That is where, when we are trying to remove him, if it is very difficult, independence of office. Independence of office can be covered in removal, in salaries, right? When the salaries are charged, and fixed, charged expenditure, independence of office is protected. Similarly, when he cannot be removed and the tenure is protected, when the removal procedure is very difficult and the tenure is protected, we can say that the independence of office is protected, right? The independence of COG is protected. He is called as a friend of opposition. He is called as friend of opposition. We will have Public Accounts Committee, which is headed by the opposition. For that Public Account Committee, he will be the friend, because the reports which he made, the audited reports of COG will be taken up by the Public Accounts Committee, review them and question them in the Parliament. So that is the reason why normally auditors, Controller Auditor Generals will be little critical about the government policies and the expenditure they are making. But here you need to understand, in appointment also, there is a different word used here. President by warrant under his hand and seal. This word makes him special. Unlike Attorney General, he is just appointed by the President. He is appointed by the President by warrant under his hand and seal. He is not just appointed by the President office. He is appointed by the President himself under his hand and warrant under his hand and seal, which means that this position is little important. Right, whenever you see such word in the Constitution, in the appointment, President by warrant under his hand and seal, then you need to understand the importance of office, right? Comptroller Auditor General is very important. The accounts which he had it, we'll try to see those accounts, right? In the due process, we'll try to see in Part 12 what are the different accounts. Normally what we are trying to see is he is accounting, he is auditing, he is also deciding the accounting standards. What should be the accounting standards in India? SNA, System of National Accounts 18 format, what should be the format of accounting will be decided by this auditor. And similarly, we have in UPSC Indian Accounting Auditor, Indian Accounting and Auditing Service, those people will work under the leadership of, under guidelines of this particular COG. COG is Supreme Audit Institution, right? He will audit the accounts of Union government, he will audit the accounts of state government, and similarly he will audit the accounts of all the public sector enterprises. When you talk about Union government, we have three statements: 2661, 2662, 267, and Part 12 of Constitution. Remember, this is same for both states and center. We have Consolidated Fund of India, Public Account of India, 267 article, Contingency Fund of India, and Part 12 of Indian Constitution. All these three accounts will be audited by him and will be given to especially Public Accounts Committee of the Parliament, where this particular committee is headed by the opposition, will review these reports and put strong questions to the government in Parliament. You need to understand, legislature is an institution which will check the power of the executive. That is where they utilize that particular right? Article 150, as I said, System of National Accounts 18, Form of Accounts of Union and States. What should be the format in which they should maintain their accounts will be decided by this particular institution. That is called audit accounting format, right? Accounting format. Accounting and audit. Audit reports, as I said, the audit reports should be, the reports of COG should be presented to the President, who shall be cause led to the Parliament. So all the reports, all the constitutional bodies normally give reports to the President, and it is the duty of the President to lay before the Parliament and discuss those reports, right? So not only this one, National Commission for SC, National Commission for BC, National Commission for ST, National Commission for Languages, all these commissions, right? All these commissions will submit reports to the President, and it is the duty of the President to lay before the Parliament, before both the houses of the Parliament, and discuss on them. So hence, Union government is done. We spoke about articles from we spoke articles from 52 to 151, in which we spoke about legislature, executive, judiciary, and one legislative power of the President, that is article 1, 2, 3. So plus COG. So in Union government, we are talking about, we spoke about legislature, we spoke about executive, we spoke about judiciary, COG, we also spoke about the ordinance power 1, 2, 3, ordinance power of the President. So I hope you understood Union government. Please try to review the articles from 52 to 151. Spend 1 hour on this. So if you spend 1 hour on this, I'll try to revise tomorrow the state government. When I'm reviewing state government, it will be really little easy for you to get into these things, right? So I'll be reviewing state government tomorrow, and 1 or 2 more sessions will complete this particular articles, important articles. I hope you are remembering the architecture of this document. Whenever you start from article 52, before 52, that this is all about fundamental rights. It is the citizen-centric focus. But when we enter into 52, remember, king used to decide, king used to make law, king used to be the executive, king used to be the judiciary. Unlike that, in modern forms of government, we have 3 different organs. We have state, we have government. State is permanent and government is little dynamic. It changes every 5 years. As I said, you try to compare the bus with the state and bus driver with the government. In this, we have 3 important organs: legislature, executive, and judiciary. All the 3 organs should be not filled by the same person. These should be different persons. Legislature should be having power over executive, checking power executive, and these 3 organs are parallel organs. It is not legislature, executive, judiciary. This is not in hierarchy. These are parallel organs. One should not grow over other. Legislature should check the executive and judiciary, executive should check the legislature and judiciary, judiciary should check the legislature and executive. This is how it should be. Balance of power should be there, checks and balances should be there, right? The tug of war between these 3 organs is very important for us. If they are fighting, we are going to be happy. Citizens are going to be very happy. If these 3 organs are in tug of war, if they are working artistically, if they are working with accounting, if they are working with accountability, responsibility, and transparency, that is called artistic mode, then there is a fair chance that citizens of the country will be happy. All right. Thank you very much. We'll try to see in the next session. Vineet, Article 143, when we talk about 143, if the Supreme Court advisory is coming, if the decision is based on Constitution, if the decision is based on the interpretation of the Constitution, then it is binding. If it is not based on the Constitution, you don't have to even tender the advice. It is not binding on the judiciary to give advice or tender advice. Even if it is giving advice, it is not binding if it is not constitutional matter. If it is constitutional matter, it is binding. Why it is binding? Because in Article 132(1) I said it is final interpreter of the Constitution. There is no other interpreter. When it is asked, when President Office is asking a question about Constitution, and if Supreme Court is giving that, it is binding on Supreme Court to give opinion. Remember, it is binding on Supreme Court to give opinion, and it is binding on President to follow the same decision, follow the same advice. So on constitutional matters, it is binding. All other matters, it is discretionary. Right? Thank you very much.